And sir, are you waiting for someone? Are you on the docket? All right, what is your name? I'm sorry? Charles. Oh, okay. As soon as your attorney comes in, we'll take you.
Outside, yeah, I think he's like putting on a film.
Oh, okay. Yep, LaShawn, now downstairs, it's like the airport. They make you pull off belts. I don't know if they.
Now you don't have to.
Thanks for history. And
Well.
Oh, girl.
I know.
Oh, yeah. Moulin Rouge.
I saw Moulin Rouge, not, you mean
Modern one.
the modern
The
one?
one that came out the night.
No, the one, I saw the one with Nicole Kidman.
Not that movie, that's old music.
Oh, what's the other one?
The new one that came to San Antonio. Like,
Oh,
now had all new music. It was so
oh,
great.
wow. Okay.
So great.
I'm gonna have to watch that. But Sean, the new season of Madame LeBlanc has started, so I've been watching that. It is on, you can watch it on Prime, but it's really Acorn. I like Acorn because it has a lot of the mystery shows, like the Rockford Files. I love the Rockford Files. Okay, they say that they're gonna reboot Murder, She Wrote. Should we just leave that alone? I'm like, leave Murder, She Wrote alone. Why don't you reboot, the $1 Million Man? Was he the $6 million man or the 5 million? $6 million man?
I watched the series.
Who's in it?
It's like Murder, She Wrote. I can see them. You know what, which one is really good?
What?
Hunting Wives.
Oh, okay.
My friends are watching that. It's great.
It's really good.
And it's definitely like adult oriented.
Yeah, it's
Okay,
very
all right.
adult.
What does that come on?
Netflix.
That's Netflix.
Hunting Wives.
Hunting Wives.
Hunting Wives.
All right, I'm gonna have to tell my mom about that.
And those Hunting Wives.
All right. Kyle, you ready on yours?
Not yet.
All right. Charles, are we with Charles Smith?
That's me.
All right, if you'll come forward.
Yes, I would love to.
Because we appeared last week on this, you just
Mhm.
reset it for the upfront restitution, which
Yeah.
has been paid this morning.
Okay.
I'm echoing.
Hmm?
There's an echo.
I don't hear an echo.
I think it's because of where I am.
Okay.
That one.
Hmm? Oh, no, Matlock is very good.
That is good.
Yes.
The
I-
newer one?
Yes, I've been telling you guys about this and you just disregarded it.
Watched it.
The new one, I was thinking the old one with Andy
With the Kevin Bates.
Kathy Bates, yeah.
Okay.
Oh, that's very good. All right, so we're just here for sentencing.
Correct. You kind of pronounced the sentence, but said you're gonna reset it to really pronounce it. Once
Yes,
we brought the 800 in of the 1600.
all right. All right, the court is calling 2024 CR 1894, State versus Charles Garrett Smith. If I can have parties announce.
Scott Simpson. Scott Simpson from Mr. Smith.
And are you Mr. Smith?
Yes, ma'am.
All right, you entered a plea to the offense of attempted fraud, Class A. You entered a plea of guilty. According to your plea bargaining agreement, punishment was to be assessed at 365 days in the Bexar County Jail. And the court wanted the restitution paid up front before the court entered its sentence. And has that been paid, counsel?
It has, but it was probation.
Oh, yes, state recommends probation.
Sorry.
All right, no problem. So has the restitution been paid up front?
Yes, Judge. So what you asked is for 800 of the 1600 and
Yes.
it has been paid, provided the prosecution with a receipt. I don't know.
I have a receipt.
And we have a receipt too.
All right. So are you ready to proceed with sentencing?
Yes, Judge.
All right, state, is there anything you wish to add to sentencing?
No, Your Honor.
All right, state, you may be excused.
Thank you.
All right, so that leaves you with a balance of $1,140
Yes.
remaining, with the deduction of the 800.
That includes the fine.
So how much are you able to pay monthly towards restitution?
I think you said last time 500, yeah. Be realistic.
250.
Okay.
I don't think that gets us,
Mm-mm.
is it 2
No,
years
it's
probation
good.
though, right?
No, it's 2 years probation. It'll
So
get
it's
us there.
okay.
All right.
I was doing it by 12 months, but
Yeah,
that's the
no,
other
no,
line.
All right, as previously stated, the court is finding you guilty. The court will set restitution at $1,104 payable to
Cross Bank.
it says Saints Peter and Paul.
We verified it. We had that discussion before because Frost Bank covered the loss.
Okay,
And so I told you I was going to verify it with the state in between now and I have with Mr. Pitluck and it is Frost Bank.
all right, so there should be $1,140. That's the remaining balance to Frost Bank. And that's to be payable in installments. And you're sure about the $250 a month?
Yes, ma'am.
All right, installments of $250 per month. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be 365 days in the Bexar County Jail, suspended for 2 years. There's to be no contact with Saint Peter and Paul
Covered.
Catholic Church. What is your employment? What do you work? What do you do?
I'm a food service. I'm a manager at a restaurant.
Okay. And there's to be 100 hours of community service restitution. Do you have any children?
Yes, ma'am.
How many?
2,
What are the ages?
12 and 6.
All right, I'm gonna order parenting classes. Once the parenting classes are completed, 50 of the hours will be deemed satisfied. And then I'm going to order the MRT course. And once that's completed, the remaining of the community service hours will be deemed satisfied. And there's going to be a field visit one time per month for 2 months. Probation, is there anything else?
Wilson County.
Okay,
That covers several counties, so he can report here, but the field visit can't be done.
okay,
It's
all right, so how far is Wilson County from here? Help me, I'm sorry.
takes me about 30 minutes to get here.
All right,
Floresville.
Roughly.
so do they do a transfer to Wilson or no?
I mean, we can, but I mean, if you want the field visits.
All right, we can do a transfer to Wilson County?
He actually comes, his work is in New Braunfels. So
Okay.
he doesn't mind reporting here, but
I
I,
have no problem reporting here.
Well, here's the thing.
but
Do
they
you
don't.
want to report in Wilson County or do you want to report here?
Here's fine.
All right,
I'm here in San Antonio way more often than I am
okay,
in the area of my residence.
all right. Probation, is there anything else? Is there anything else you need from the court in order to be successful in this probation?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, good luck to you. Just go over conditions with probation and then you're excused.
Yes, ma'am. And I can pay extra monthly if I'm able to. correct?
Yes.
Yes, yes.
Do you need my notes? Yes. But Sean, because nobody can read my notes.
Yeah. There's some crazy classes. Couple of good options on it. Make sure it's like 14 hours. Are you talking about yourself?
You want to buy it? I already have it. I was going on my. I got dogs. We'll go together.
Anyone else ready?
We're working on people.
All right, thank you. All right, and Norma, who's the attorney in the public defender's office for Yvonne Ordonez? All right.
You want me to call him back?
Yes, because we haven't, where is she? And she didn't show up. So let him know he can appear by Zoom. And then Sonia Haga.
Sure, we have more, but I'm gonna ask that you would Steve also today to both get it to my team, but never show cheating.
Okay.
And she does. I don't think it's time. Well, I'm not sure. She can move it to the. Yeah. We made it. Chair has to be recalled today. She was going to be resolved for.
Okay. All right, thank you. Hello.
Hey, Judge, good afternoon.
Hi. You have,
Just one quick matter, Judge Yvonne Organos.
yes.
On her thread, just not it's kind of.
All right, could I see Yvonne Artemis, please? And is she on a PR bond?
It's a criminal mischief case, Judge. I know that, so I do believe she is on a PR, limited criminal history.
Let's see. Oh, no, it shows that a bond was made.
Oh, okay, it was a bond company.
So I don't know if you want to see. Norma, on my end, it's showing a bond has been made. Do you see who the bondsman is? I don't know if you want to call the bondsman.
Certainly can't hurt at this juncture, Judge. I agree. I don't mind giving them a call. 'Cause, I'll split that info with you and then I'll try to get the hold of them and I'll get.
Oh, I can tell you who it is. Just one moment.
Triple A Garcia.
Yes.
Okay, cool. I'll give him a call, Your Honor, see if I can find out.
Okay.
Yes. Yeah, of course.
I responded. Okay. On Beltron, right?
Yes.
Okay.
We haven't updated the system, about the line and the.
Okay.
Yeah,
Oh, and then, I'm sorry, that goes with that, that's all. You're welcome.
Yeah. So they don't want to know why.
So we see people.
Yeah. So that's more accurate. Yeah, yeah, that is. I know. They have to what? Right. No, it's not. How do you go? Oh.
Yeah.
Oh, thank you. Portable.
I'm so actually, I don't. It's like.
I think.
Really. So good. Like. No, he's talking. That's the one that they call the court. So it's I think that's safer. Every approach.
Yes.
On this, so Judge, I spoke to the bond company and they gave me a new number for her. I did call and leave a message. This is the new number that I got from her from the bond company, so maybe a new and updated number. I wanted to see if it could be possibly called to tomorrow. I know the bond company said that they're gonna reach out to her too, try to get her here. But if at all possible, I'll be here tomorrow, Judge. Maybe she'll hear my voice message.
You see if the state has any objection to just recalling it for tomorrow, because I see that it's not a violent offense.
Okay, yes, we'll do, Judge.
All right, thank you. Right. So Vashon, where I left off on Matlock, I was at the episode where her employer found out she's not who she says she is.
Not yet.
Oh, I'm so sorry.
It's okay.
What episode are you on? Are you in the first season?
Yes.
Okay, then that's your fault that I told you, because you should have said, hey. Yes. No, actually, Deputy Laura, I'm wrong. That never happened. Didn't happen. But I love her little grandson. Now, see, that reboot really wasn't a reboot, but I liked it. But I am gonna watch the new episode and see if Tony and Ziva, if that's good.
You're changing it up on me, like there's a mistake.
But Vashon, I never knew there was a part 3 though. Cowboy Carter. I never knew there was a part 3. Ah. Mhm.
Just based on things that were going around.
Okay. Okay, let me just tell you, one of my friends said they were watching it because somebody was live streaming it. And they said, you will not believe this. Someone's live streaming it. And they said, it's like you're at the concert. I guess they didn't take people's phones. And then she said, people had nerve enough to be complaining to the person who's live streaming it. Why are you yelling? Stop singing along to the song. It's like, I bought that. I would have said, I bought this ticket. You didn't. I will sing along to the song.
That's crazy.
Are you guys testing your teams the other day?
Sorry, what?
Was just testing your teams?
Yes. And I see that it went through.
No, it's the correct way.
All right.
But I'm sure you believe in your conversation or anything. I don't even know you guys. I should check my stuff this way. Do you wonder if you have anything? It's. She goes. It's the agenda. Oh, there's. It's. Well, no, I left it for you to take a look at. Okay. I'll let you look at.
I got this Wednesday.
Hmm.
This Wednesday.
Yes.
You did get it. Yeah, you have all the dates set it, it's here. The dates we took both Sabbath. Days, that we talked about. Okay. So the only one. This one here, or this one. This one is financial. Oh, there we go. Release. Okay. 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 Okay, if you don't put the hard work at the well, yeah, that's it.
Can you hand these, please?
Sure.
Thank you.
No, the show on this one. Okay.
You know, that's contagious.
No, let's see if, maybe have him come in and see if we can get him back on track to getting employment. And then this one. I'm assuming the state is okay with this and she's going to res care.
Oh, I didn't even ask them because it was within the state of Texas,
Okay.
I believe.
Yeah, because she's supposed to reside in res care, so I'm assuming everybody's okay. Here's this.
Thank you.
You're welcome.
No.
State, are you okay with recalling Renee's case for tomorrow? It's Yvonne Ordonez. Sure.
I was trying to get a discovery. It's like it's not able to get into. So you can access. But I was going to request this platforms out there also once for setting.
Oh, okay.
Oh,
Oh, shit.
yeah, they're here today, that's fine. I was going to use a couple weeks ago. I don't know.
We're good, yeah, we're fine with it. There's just a call back for her to show up.
Yes.
Okay, that's.
All right, so I'll put her down for tomorrow.
Okay, good, I'll be here.
Thank you. No, that's on Ordonez.
Yeah.
Lorraine, every time I see you lifting, I'm looking at myself saying, Stephanie, get off this couch.
It's like an inspiration to us.
It is.
Outlive all of us.
Yeah. And then she has the music playing, she has the earphones in, and she's just making it happen.
I go to a different place.
Yeah. I'm gonna join you and you're gonna say like, Stephanie, surely you can lift more than 20 pounds.
I don't think the lifting's gonna kill me. I think it's like weird stuff like me tripping on it.
I'm pretty heavy, Judge.
Oh, yeah. That's true.
I started doing a little bit. It's just stop.
I remember watching this Western and they were in a shootout and this old guy was with him. He had to be about in his late 90s. And so they're shooting and he's like, it's not the fall that gets you. And then somebody gets shot because they're on the mountainside and he falls and then splat. He's like, it's the landing. So if you can just keep falling, I guess you'll be okay.
Yeah. I don't know which one it's in the way for. There might be some other state. Okay. Are you with the buildings house? Are you familiar with what's the simulation? You saw that truth for Western knowledge. All right, has the central bank got to open the right to do understand? I'll do it for them. Let's see.
I am.
Yes. I know that you always up.
Okay. It sounds like that printer needs some WD-40 or something. Yes. Oh, they're gonna wait till it die. All right. Oh, no problem. Okay. All right, you're ready on Carlos White?
Yes, Your Honor.
And are there gonna be any applications?
No.
Okay. That's a beautiful color.
Thank you.
All right, the court is calling 2025 CR 002218, State versus Carlos White. Can I have parties announced?
Jason Garrett for State, Your Honor.
Lauren Lupton for Mr. White.
And are you Mr. White?
Yes, ma'am.
All right, just one moment off the record. Deputy Laura, could you have them move to the other end? All right, we're back on the record. Mr. White, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? All right, I'm gonna need you to speak up a little bit louder so I can hear and the reporter can hear, okay?
Yes, ma'am.
All right. Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the enhancement paragraphs and proceeding on the state jail.
Any objection?
No objection, Your Honor.
Mr. White, did you review the court admonishments with your attorney?
No.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony.
Thank you, Judge.
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? I'm sorry?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. White, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 180 days in the state jail facility, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right, state any evidence?
Yes, Your Honor. State exhibit number 1 with all of its attachments.
No objections.
Did you review the waiver and state you may be excused? Did you review the waiver and stipulations with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
The only thing I would say is, Mr. White and I did explore many options for alternatives to this sentence. And I commend him for being willing to participate in specialty courts, and unfortunately, he just wasn't accepted into any of them. So I hope he seeks continuing care upon his release.
All right, what are your plans once you're released? Do you have a place to go?
Yes, my sister wanted me to go live with her, but I'm thinking about going to the Haven for a home.
Okay,
And I'm gonna work with his family.
all right. So you're probably, when you're released, the best thing that you probably can do is go to Center for Healthcare Services. You understand?
Yes, ma'am.
Because otherwise, what's going to end up happening is you're going to keep getting arrested. You understand?
Yes.
And I understand that sometimes when people have mental health issues and they're not on their mental health medication, then usually they resort to using controlled substance.
Mhm.
And those controlled substances are against the law. You understand?
Mhm.
And I've read the police report, and the way you're presenting now is not the way you presented in the police report. So that tells me that when you're on your medications, you're fine.
Yes, ma'am.
And I understand that sometimes medications, they have side effects and then you don't want to take them. Or either sometimes you say, I'm feeling great, so why am I on meds? But for you, you're going to have to stay on your medications. If there are any side effects, you're going to have to let the doctor know, because otherwise, more likely than not, you'll end up back before a criminal judge, and you don't want that.
Yes, ma'am.
Okay. All right. This is the court is going to do. The court is going to find you guilty, sentence you to 180 days in the state jail facility, give you credit for any time served, and I'll request the therapeutic community. It doesn't increase the time that you're in custody, but it's just a program that's designed to help you with your mental health, to help you with your drug addictions. Do you understand?
Mm.
So you will serve no more than 180 days, but you're receiving credit for any time that you've already been in custody on this offense. Do you understand?
Yes, ma'am.
Is there anything you don't understand about my sentence?
Mhm.
All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So here's the thing. When you are released from the state jail facility, if for some reason you can't find a mental health facility, or you don't remember this, because sometimes people go and they forget, right? You can come back to this court and I will pick up the phone and call a place for you, okay?
Yes, ma'am.
All right, any questions about anything? All right, good luck to you, okay?
Thank you.
You're
Talk
welcome.
to your family, okay? Thank you, Judge.
Thank
I
you.
Appreciate it.
You too. Have a good one. You're welcome. All right. All right, who is here on Nicholas Gonzalez? All right, Nicholas Gonzalez, if you'll come down. Court is calling 2019 CR 11182, State versus Nicholas Paul Gonzalez. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Lorraine Efron for Mr. Gonzalez.
Are you Mr. Gonzalez?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney?
Oh,
It's this document. It's the document that tells you you're on probation, and it tells you what violations the state is saying you committed.
okay, no, I haven't seen that.
All right, then we'll let, just 1 second. I think she's grabbing it for you.
And she'll ask you.
All right, so did you review that?
Yes, ma'am.
Did you understand it?
Yes.
Are you the same Nicholas Paul Gonzalez who was placed on community supervision in 2019 CR 11182 for the offense of harassment of a public servant on June 12, 2020 for a term of 4 years and extended for 2 years? Is that you?
Yes.
All right, state, you may proceed.
Violation of condition number 5. In Bexar County, Texas, the defendant, Nicholas Paul Gonzalez, did then and there fail to report to the supervision officer as directed for the months of February, March, and April 2025 in violation of condition number 5.
To that, how do you plead? True or not true?
Not true.
All right, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, and sentence you up to 5 years in the prison and up to a $500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
There is not an agreement, Your Honor.
All right, state, what are you requesting?
State is requesting that you grant the state's motion that we revoke probationer and we sentence him to 5 years.
All right, in defense, what are you requesting?
Mr. Gonzalez has been to ISF and safety. He actually feels like those programs helped him, even though he's still here and struggling. And even though we're pretty far into this probation, and I've talked to him at length about it, he really desires to continue and stay in the programs. And I think if the court will allow, the state will allow, he'd like to say a couple things with regards to that.
All right, do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
Right, you can lower your hand, state your name for the record.
Nicholas Paul Gonzalez.
All right. What would you like to say to me?
The ISF helped me out a lot with a place to stay and a direction to go on correctly. St. P basically did the same thing, but they didn't help me with a place to stay. I feel like the best option for me would be to get time to spend to get my mind right with the counselors and the teachings and everything else they could give me to shoot me in the right direction. I feel like if I were to go to jail or somewhere where I'm surrounded by nothing but negativity, something could happen to me. I could mess up even worse on the inside. I just feel like the best thing for me, for my personal health and well-being, would be to go to a program to continue getting the mental health and the physical help that I need from the state.
Okay.
And I know he's pretty far down on the probation, but I don't think he has any new offenses. I think it's failures to report, maybe failed drug test. And the probation documents indicate that full diagnosis was considered, and I'm not suggesting necessarily that it should be, but anyway, he would like resources to get back on his feet, find a place to live permanently, correct?
Correct.
All right. So, Mr. Gonzalez, I want you to know that I've heard your plea. I've heard your attorney's argument. And I want you to know where I'm coming from, right? So you were placed on probation, and I understand the mental health issues. Normally, when you have a harassment of a public servant, there's usually some mental health issues involved.
Yes.
I always find it concerning when people are in mental health facilities and they assault someone, then we come back here. But here's my, yes.
Between me and the officer, it was a miscommunication.
Oh, no. So let me explain something to
Sorry.
you.
I
No,
was
no, no.
gonna let you know what happened because I feel like if he had spoke to me differently, I wouldn't have did what I did because he had called me crazy and I thought he was disrespecting me. So I disrespected him back. I spit on him on his leg. He wiped it back
Well, here's
off
the
onto
thing.
me.
But
And
here-
then later he told me that the reason why he had said what he said, because he said, you need to go to a medical unit, you need to go to a mental unit, don't you? He said it was miscommunication. I wasn't trying to be rude and call you crazy. I was trying to make sure that I placed you in the right place you needed to go. And
Here's
I
the
wish
thing,
that I
Mr.
understood that when I had heard it.
But I
It
understand.
was
But
just
here's,
like a quick reaction and I shouldn't have
but
did
here's
it.
the thing, Mr. Gonzalez,
Yeah,
that ship has sailed
yeah, for
as
sure.
far as while you're on probation, or the reason you're on probation, because you've been on probation, for a while, since 2020. And I want you to know where I'm coming from. I always want to give people conditions that are helpful to them. I see people as individuals, and I try to give them conditions that is for that specific individual.
Okay.
So if that person has a drug problem, I try to give them drug treatment. If that person has mental health issues, I try to do that for them. But the key thing about all of that is you can't help somebody who doesn't want to help themselves. You can't help somebody who's not showing up, right? And so you were here on August 5th, 2020 for a motion to revoke. And that was a violation of condition number 5, which is not reporting. So what ended up happening is there was a jail sanction, and then you were continued. Then May 17th of 2021, another number 5, failure to report. Your conditions were altered and amended to include a MIC evaluation to address whatever mental health issues you may be having. And then on August 22nd, 2022, you had a violation of condition number 22. And again, try to help you with that by doing a TAP evaluation in custody, because there were some drug issues that maybe had not been previously addressed. And there was a referral for the Center for Healthcare Services. Then you come back on March 2nd, 2023, violation number 5, not reporting. It was denied. and both parties wanted, and probation agreed, and the state agreed, they wanted you to go to ISF two and have you placed back on the mental health caseload. Then, prior to all of this, let me see, not prior, but on March 26, 2024, you had a violation of condition number one. And then I tried to have you referred to felony drug court and you extended for 2 years. So now you are here today on a violation of condition number five. There is nothing else that I feel that can be accomplished for you by keeping you on probation. I don't think you're a good candidate for probation. So what I'm going to do is I'm going to revoke. I'm going to sentence you to 5 years in the prison. Give you credit for any time served. There'll be credit for any successful completion of inpatient treatment, which legally I'm required to give you credit for that.
There's 59 days in the aftercare program that.
Not the aftercare. Yeah. Legally, I'm not required to give you time for that, and I don't give time for the care program. I'll request the therapeutic community. And there is to be a $500 fine, time and money to run concurrently. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. You have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. When you're released from custody, if for some reason you can't find any location to help you with your mental health, if you come back here and I'm still here, I'll make sure that a placement is found for you.
I'm sorry, I misspoke. I missed the new number one.
Yes. Oh, no, that's fine.
Okay.
The docket sheet, because they're doing Odyssey, sometimes it's misplaced. Yes.
He has maybe like 304 days credit in county and 300 more or less days from the programs he's been in.
All right, just check with the clerks and they'll make sure he receives appropriate time.
Okay.
All right, thank you. All right, after this, we're gonna do the motion to suppress. Kevin Zachariah Rodriguez. Just give me 1 second. Mr. Brooks.
Yes, Judge.
Mr. Brooks, I'd hate for you to have a CPS case. And then I'll get called as a witness.
Well, my office is right there. She can walk, I think.
You're gonna let a 4-year-old walk across the busy streets?
It's actually 8, the little one's 4.
Oh my gosh. All right. Court is calling 2025 CR 006-732 State versus Kevin Zachariah Rodriguez. And this is an application?
Yeah.
All right. Probation, this is an application. Could I have parties announce?
Jason Garahan for the state, Your Honor. Kyle Simpson from Mr. Rodriguez.
And are you Mr. Rodriguez?
Yes.
Counsel, have you received all discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Rodriguez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Rodriguez, did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand your charge is possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, I understand.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Understand.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Very satisfied.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I understand.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They will take into consideration 2025 PF 28602. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can, oh, you okay? The only items that can be appealed, I'm sorry, did you understand by signing that you're waiving your right to appeal?
Yes.
The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I understand.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be a TAP evaluation, 120. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor, Student Exhibit number 1 with all of its attachments.
Without objection.
All right, state, you may be excused.
Thank you,
Did you
Judge.
review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call on the right to remain silent.
Yes, I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
I understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you would say on behalf of your client?
We'd ask to follow the agreement.
All right. So how old are you?
31.
All right, do you have any children?
Yes.
What are their ages?
8,
4, and then I think the other one,
I'm sorry.
I think 8 and 4.
All right. Is there a reason you're unsure?
I haven't been involved in it like too much,
Okay.
as much as I would like.
All right. So when did you start using drugs?
I mean, I haven't used them since 2014, so,
I mean, no, this case is not from 2014. This case is.
no, I know, but this was just, me using someone's car and there happened to be drugs in the car.
All right,
There was no using involved.
but you told them that you were responsible for what was in the bag.
They said because that the car was gonna be inventoried,
Mhm.
since there was no proof of insurance, so. So I mean.
But I
don't know
mean,
what
you
else
told
to
them,
answer.
but you told them the backpack wasn't yours, but you said what was in the backpack
Well, the
was
car
yours.
wasn't mine at all. I'm not sure what I was supposed to answer them, you know, they just told me that the car was gonna be inventoried and anything found in the vehicle was gonna be charged to me, so.
All right, well, do you want a jury trial?
No, it's fine, I just wanna get out.
All right.
Talk
So,
about all that at length and also the basis for the stop. And the involvement.
how far did you go in school?
I graduated,
All right, so where have you been working? What have you been doing with your life?
well, besides being in and out of here, I mean, I was working for a good amount of my life and.
Doing what?
And then, I was just working different jobs, you know.
Doing what?
Call centers during.
All right, so what do you mean when you say other than being in and out of here? What is in?
Well,
and
once
out
I
here?
started being in and out of here a little more often, that's when things started
Out of
getting put on
jails?
hold, you know, or just in county.
All
And,
right.
that's when things kind of got put on hold, you know, of course, my family couldn't hold on, so they had to keep going. And
So do you
that's where it
have
leaves
family?
me in my situation with my kids, but,
So do you have any family support?
no.
All right, so here's the thing. I set conditions so that people can be successful. So if you have a drug issue, now's the time to tell me. If you tell me you don't have a drug issue, I'm going to notate that you said you didn't have a drug issue, which would mean you shouldn't be testing positive because I'm going to order that they drug test you.
Okay.
And if you come up positive, you know what's going to end up happening?
Mhm.
That's 100% on you because you told me that you don't have a problem.
Okay, I don't have a problem.
All right. So you don't need any type of drug treatment?
No.
All right. I'm gonna notate that you said that you don't have a drug problem and you don't need drug treatment.
Okay.
All right, that's a $1,500 fine. It's gonna be probated. 2 years deferred adjudication. I'm gonna want the UA hotline for 6 months. Then there'll be regular random UAs after that. Field visits. 1 time per month for 6 months. Regular reporting by Zoom or in person. 120 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's to be no contact with the following locations. Proof of employment within 30 days. No employment as a home healthcare provider or with minors. And there's to be no residing with minors. Take in consideration 2025 PF 28602. Probation, is there anything else?
Judge, tell me the code that her car go out.
It's 78220.
Nothing else.
All right, is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
To be successful on probation in this courtroom, communication is key. If you have an issue, let probation know about it. If you feel they're not addressing it, you can always come back and address it with the court. All right, thank you. Thank you.
Have a seat.
All right, and then Deputy Laura, in this case, they're gonna be witnesses. Yes, please. Yes,
There's feedback?
no, but do we have the mic up there?
Not yet.
Oh, could I have the, one of those mics, the small one? Yes. Yes.
Thank you.
All right.
Yeah. Is he gonna sit on with you?
Yes.
Guys misplaced your dolly is behind the door. You flat.
Last week?
Yeah.
Speak for it. Right.
All right, so this case that I have now, is this the only case? Do y'all have the paperwork for this one? Alan? Mhm. I think this is the last case we have on the docket, correct? Yes. All right. Yes. All right, court is going to call 2025 CR 007563 State versus Ronald Allen. Can I have parties announced?
Duffy Pitlock for the state of Texas with Eli Mireles.
And Megan Galloway sitting as a supervisory attorney for Eli Gonzalez, who has a student bar card currently.
All right, thank you. And do you want to make an announcement so your voice can be on the record?
Eli Mireles for the state.
All right, thank you. And for the defense?
My name is Charles Butcher, and I'm here for the accused.
All right, and who's sitting with you?
This is my
Intern.
my intern. She's gonna help me with the paperwork.
All right, no problem.
Her name is Angelina Jolie, and she's a candidate for St. Mary's University next semester.
Oh, your name is Angelina Jolie?
It really is.
Yes, yes.
Hi, I may have seen some of your work. No problem. Deputy Laura? I'm getting feedback. I thought you were joking when you said that.
No, it really is.
It's
Yeah.
Angelina Jolie Beauty, yeah.
And incidentally, Angelina Jolie, the actress,
Mhm.
has the same birthday as me.
Get out of
So
town.
that's why I said, okay, you're hired.
But I'm sure she's doing fantastic work.
Doesn't want to work.
Okay.
Oh, wait.
You got it?
No, did you press something?
Mm-mm.
It shouldn't have a feedback.
All right, testing, testing. Okay, we're good. All right. The last time we were here was for a motion to reduce bond. That was taken care of. And now there's a motion to suppress and a motion to dismiss. Is that correct, defense?
Yes, Judge.
All right, and which motion do you wish to proceed on first?
I think we should begin with the motion to suppress.
All right, and let me just review your motion. All right, state with regards to the motion to suppress, are you stipulating that the defendant was arrested without a warrant?
We are not, and state would tender at this time State's Exhibit 5, which is the warrant. We understand typically when there isn't a warrant, that would shift the burden. The state is still prepared to begin, but we would tender the actual warrant pending examination. Defense.
Judge, I'll stipulate to the fact that there was in fact a warrant issued. Would stipulate to that.
We
All
would
right.
still like to enter it. It may come in through one of our witnesses.
All right, and that states exhibit number,
5.
just one moment. So any objection to states exhibit 5 for the purposes of this hearing only?
There's no objections to that.
All right, then State's Exhibit number 5 will be admitted for purposes of this hearing. And the court will note for the record that the defense has stipulated that there was in fact a warrant. So because there was a warrant, defense, you may proceed.
Well, Judge, when we begin with our motion to suppress, we believe that the central issue here is not the warrant, so to speak, but that the state's primary evidence comes from a secretly recorded attorney-client conversation between Ronald and his former lawyer, Mr. Ireland. The conversation occurred in a confidential legal setting during a time of high emotional stress on the part of my client, and in a context where Ronald was actually seeking legal advice and not making public threats. We argue that the recording should be suppressed for 2 real core reasons. First off, there's a breach of confidentiality and the attorney-client relationship. So even if Mr. Ireland is a party to the recording, this was a protected consultation. The decision to record, share, and weaponize that conversation violates the principles of trust and candor embedded in our legal system among lawyers. The second reason that we think that the recording should be suppressed is because the resulting statement, it lacks reliability. The state offers a paraphrase.
All right, counsel, just 1 second. If we can start with, you're saying that there's an attorney-client privilege that's been violated by the attorney?
We believe that.
Okay.
And the reason for that is there's disciplinary rules regarding attorney-client confidentiality privileges. This was a privilege that was asserted repeatedly in the transcript that the court shared with me today that was tendered over from the civil court. It was repeatedly mentioned that there was an attorney-client confidentiality that was asserted by the attorney in question that disclosed this information to the state.
All right, so just so the record can be clear, with regards to the transcript that the court gave to both attorneys, the court has not read that transcript. That transcript was just sent to the court.
Sure.
And I don't open the email, so I don't know what's in the transcript.
Sure, sure, absolutely, Judge. But we do know that the complaining witness in this case had a contractual relationship with Ronald Allen and that he was his divorce and custody lawyer. And this conversation, according to the state's evidence, my client and all other indications occurred in that attorney's office in a confidential setting, and it was recorded without the knowledge of Ronald Allen. And we believe that it was weaponized by the attorney because of a contractual dispute, because of problems with the representation that were occurring, that were being discussed in the recording that is in the state's evidence, the state's discovery.
So with regards to your stating that this was some sort of attorney-client privilege, unless someone is going to stipulate that there was a conversation that was had between your client and the fact that your client had this conversation with his then attorney, you know, that evidence needs to be presented before the court unless there's going to be a stipulation that whatever conversation occurred, it occurred with your client's civil attorney. I don't know, is anyone going to stipulate that there was a contractual agreement between Mr. Allen and Mr. Ireland, and that during that representation, there was a conversation between the two? Is somebody going to stipulate to that?
Yes, Judge. By the end of the day, if the state has their witness, like they say they do, we believe that Mr. Ireland will testify, and he's the complaining witness on this case. That's our understanding.
So who is calling the witness?
The state does have 2 witnesses ready, and even though there wasn't a warrant or there was, and burden has shifted, the state has our witnesses here, and if defense wants to call our witness and then have him available to us on cross,
Right.
is available.
All right, then defense, because there was stipulated that there was a warrant, then the burden does shift to the defense. So what witness would you like to call?
Okay, okay, we didn't get a witness list, so we're just looking at this right now.
No problem.
Let's call Mr. Ireland. Charles Michael Ireland.
Okay. Hello. All right, I recognize you as an officer of the court. However, if you could raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can have a seat. If you just, there should be a square microphone. It's for the court reporter to hear. If you'll click that on your lapel or somewhere. All right, if you'll state your name for the record.
Charles Michael Ireland Jr.
All right, you may proceed, defense.
Mr. Ireland, were you Mr. Allen's attorney during a portion of his family court case?
Yes.
And the meeting where the recording was made, you made a recording of a meeting that you had with him. That meeting where the recording was made, that took place in your office. Is that correct?
Your Honor, leading.
Sustained.
Where was the recording made?
In my office.
All right. And do you know if Mr. Allen believed he was speaking with you in confidence because of the contractual relationship you had, or did you have some other arrangement where you had already told him that you were getting off the case?
Objection, Your Honor, speculation.
Sustained.
Why was he in your office?
I believe that's attorney-client privilege.
And so the conversation, you would agree that the conversation that you had with Mr. Allen was attorney-client privilege, correct?
Yes.
And well, that's all I have for right now, Judge. I'd like to pass the witness.
All right, state.
Your Honor, may I approach?
Yes.
Well, I am showing you what has been pre-marked as State's Exhibit 1. Do you know what this is?
Yes.
How do you know what this is?
You provided that to me this morning.
When you say provided, do you mean I gave this to you or you listened to it?
Both.
And what is this?
It's a recording of the conversation I had with Mr. Allen.
What date did that happen?
I believe it's April 21st, 2025.
And are your initials anywhere on this?
Yes.
And is there a date associated with your initials?
Yes.
What date is that?
Today's date, July 28th,
What year?
2025.
And when you listened to this, was it an accurate portrayal of the events that day as you remember them?
Yes.
Was it altered in any way?
No.
Your Honor, at this time, State moves to enter State's Exhibit 1 for purposes of this hearing pending inspection by defense.
Yes, I see that, and that's been provided to me.
Any objections for?
No
purposes of
objections,
this hearing?
Judge.
All right, State's Exhibit number 1 is admitted for purposes of this hearing.
We have downloaded it. The state has to expedite things, but before we play it, I may ask you a couple more questions. You on direct stated that you agree the conversation was attorney-client privilege. Is that true?
Yes,
Did you believe the entire conversation was attorney-client privilege?
no.
What sorts of things are not privileged under that attorney-client privilege?
Mr. Allen said some things to me that I believe clearly established that he was going to attempt to or commit an act that would cause bodily harm or worse to one or more individuals.
Do you recognize Rule 503 to be the rules of evidence for attorney-client privilege?
Yes,
And in that rule, there is an exception. That's true, right? There's multiple exceptions.
there's multiple.
There's an exception that says the privilege does not apply in furtherance of a crime. Is that true?
If you say so.
Well, in this conversation that we're about to hear, something alarmed you, isn't that true?
Yes,
And you believed that the attorney-client privilege no longer held because of that statement.
I believe that because of what was told to me, I had a mandatory duty to report it to authorities.
Your Honor, at this time, state is going to play what has been entered as exhibit 1. It is around 12 minutes, 54 seconds. We'll play the entire thing.
Thank you.
State's exhibit 1 is now played.
Hey, Ron. I'm gonna show you.
Hey, I said we were in the courtroom. Your face got so fucking easy, if you was so fucking, do you have this or not?
Nervous?
Yeah, you look nervous, you were very scared.
State has paused it at 45 seconds. Whose voice do we hear in this recording?
Mr. Allen's and my voices.
May you point out and identify Mr. Allen by an article of clothing for the record?
He's a gentleman over there in the orange jumpsuit.
If the record may reflect that our witness has positively identified the defendant in the courtroom. And the second voice, whose voice is that?
That's mine.
The state will resume playing at 45 seconds.
Fidgety and not look at your face and you were so red and blotchy, like when somebody gets put on the spot or something like that. Can you handle this? Because history's going to get made Wednesday, right? I don't have to deal with this after Wednesday. I know for a fact. How are we gonna do that? The answers we need already happened. You know how I know? Because I sent Keith a message at the beginning of this, and I told him, you're playing for the wrong judge. There's only one judge, and it's Aiden. I have all the evidence. As soon as I did that, I've never seen him again. They know it's there. That's why they're rushing around. I got called into jury duty the same week in the same courtroom. The odds of that is like me winning the lotto 20 times in a row, bro. It doesn't happen. There was 2 girls in that courtroom. Those 2 girls are the same ones in that hallway when they didn't show up in the court and we were talking loud in the hallway. They were fucking, and they asked me over and over and over, does anybody recognize anybody? Does anybody recognize anybody? Over and over and over. Those 2 girls and Justin was up my ass. Are you in on this or not? Because I'm gonna call the FBI tomorrow. Because I don't know who else calls. Because I've talked to you and still nothing has been done.
If you're not happy with my services, you can fire me, but I'm not gonna sit here and be questioned about whether I've got this or not.
Well, you know what? Why haven't you called the DA? Because there's definitely
What criminal charges? I'm a civil lawyer, right?
That same lady who's signing all these things.
What things?
Okay. This guy, he's got a TRO, right? The ex-boyfriend or the boyfriend.
Oh,
He's got-
Sherwood?
Right, and it's sealed, right?
Yeah.
Why would you seal something? And because if you don't care about it if it's her,
No,
you would still
protective
have
orders are
kids.
sealed by law. There's a
Okay.
statute.
Okay. So that's happening at the house. I guarantee you the same month, that same judge who signed that for her, signed something that says I can't have Aiden or something. And it's there. We went to court that same month. How does that not show? That just, they're there every day. It shows, that's a huge conflict of interest right there. What happened is Tiffany didn't need a signature and she went and did this. Torres signed to keep her ass out of jail. And then what you got is Torres, yeah, the next 2 times she ruled in my favor because she had to. Didn't stop Tiffany from bringing her. Tiffany already knows she's not going to get in trouble. That's why she's not doing this. And they're looking there trying to set up in the thing, so I fuck up. And they're putting me in a bubble. Do you see that at Kidshare? Every time I've been to Kidshare, it's, oh yeah, nobody called me or nothing, said there was gonna be a cancellation until I get up there, and then I hear half the story. Then I go the next day and it's, oh no, the whole weekend. Oh, you talked to her again? No, we talked to her that day. You said she just wasn't gonna show up that day. And then, you see what I'm saying? The information goes, they're creating a scenario for me to make a scene. And I'm not gonna see Aiden until that happens. There's no doubt in my mind.
So nothing about this case scares me.
Well, I'm scared,
Okay, I mean, I think that's healthy.
but not about Aiden.
What are you scared about?
I'm scared for my life, dude.
Okay, why are you?
Because
scared
there's
for your
something
life?
there. There's something there. There's something there. There is something there. We're overlooking something. You cannot tell me all this stuff that's going on. I see extortion. I see
Oh, no, I mean,
kidnapping.
I think you're getting fucked for sure.
I see kidnapping. I see extortion. I see obstruction of justice. Dude, all this stuff. Tiffany falsified that document and just presented it on me. He gets a signature from Torres, and then Torres gets my case the next 2 times in a row. What are the odds of that? How many times do I have to do this? Right. And then I have jury duty, and then they're asking if I'm
When
right.
did you have jury duty?
The next week.
Just a few weeks ago?
Last week, bro.
I didn't know you had jury duty
Yes,
last week.
that's it. Nobody's telling you everything, dude. Yes, I had jury duty, dude, and Justin was it. There was nobody else. Nobody else. Dude, they asked me certain questions. They made me sit there all day.
Whose court was it in?
Fucking the same fucking judge.
Torres?
Yes.
Oh, that's fucked up.
That's what I'm saying. The odds of that happening is they wanted to know what I knew. Or if I recognize those other 2 girls. They're fucking relaying message. When I go to court and they don't show up and they hit it from Zoom, they got 2 lawyers in the fucking hallway talking about our deals. Justin was next to me the whole fucking time. If I was Justin, I wouldn't want to see me. Justin was next to me the whole fucking time in the hallway. He wanted to know what the fuck I knew and who I was talking to. There's no doubt I know this shit. There's something there. And the fact that
Are you talking about the 2 girls who were sitting outside when we went to court?
No, I know exactly who they are. They represent Via. It's 2 girls.
Okay.
And at the end, the judge gave a long speech about, you got to see our, how we work and blah, 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 this and blah, 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 that, and this and that. That one girl, mad dog, ain't they ever living shit out of me the whole time. And then the other girl was like, just talking or whatever, but we're listening to the judge. The chubby girl didn't really, she was the one asking questions. The other girl, she didn't look at me the whole time. And then at the end, when that judge was giving that speech, it was like it was directed towards me. And she was mean mugging me the whole time. Who does that? You know what I mean?
Do you want to know why I was mad when we were there and my face was red?
Why?
Because I knew we weren't going to get a hearing. Because we sat there and we sat there and we sat there.
And it's not gonna happen. I know Wednesday, something changes.
I hope so.
And it's in my favor. We're going to find something. It's there.
Well, I've been arguing with Martha for 3 days.
Martha is a distraction. They're doing that to distract you from looking for what you need to be looking for.
Come in.
There's no doubt in my mind. These guys are tricky.
So it's the subpoena for Sherwood.
Who?
Sherwood.
Allen?
Yeah.
Absolutely.
Is he friendly to us? You think he'll be friendly to us?
Yeah,
we're about to send it out.
Yeah, I've never done anything to him. Why wouldn't
Do
he?
you have a phone number for him?
No, I don't know.
We just have that address.
Absolutely, because she fucked him. You know what? She's following the exact same play. It's like Medley talked to her and showed her the blueprint, and they've been following it to a T. She was with him. They broke up because there's a protective order, obviously, there. They got back together because I run into them at the this Target or whatever. And then he's gone. He didn't tell me, Alan's gone or whatever. She's pregnant. Now she's got something to hold over his head and take money from him and extort him just like she's doing to me. That's exactly what happened with me and A. I kicked her out on 4th of July. She said, can we get back together? She went, made a Bakeland police report, said I choked her, and then figured out that there's nothing she can do. She would have to go back home to her parents' house. She called me offshore that same day. That testimony, but that recording, she spends more time talking about how do I get this guy to pay and me stay in this big ass house in Wimberley and him never coming home again. And she calls me her spouse. She doesn't even refer to my name in this thing, okay? This is from the very get-go, and she forced me to it. She said, save our family, sign the deal. So I signed it. The next thing I know, she turned it around and I've been fighting for Aiden ever since. She's gonna do that with Alan. The exact same thing. She did it with the other guy.
I'm assuming you haven't heard from Esparza.
No.
I'm assuming you haven't heard from the amicus.
Right, and I mean, all this together, doesn't that paint a pretty big picture? They're refusing to sign this, they're refusing to do that. After they were on my side, the only reason they came on my side is so they don't look so guilty. But yet I got $2,000 bills all of a sudden from the amicus and this and that.
Yeah, I don't know how you said. I got that.
See what I'm saying? It's extortion, it's kidnapping. Everybody's dirty on it. They called me into jury duty, bro.
I mean,
Jury tampering. I guarantee it.
here's the deal. I'll do whatever you want me to do. I will go there and fight whatever fight you need me to fight.
I think that we need to get somebody else involved. Okay, so we get all this information. Who are you gonna take it to?
To the judge, that's the only place I can take it.
The same judge that's dirty?
Well, I don't know who the judge will be.
Well, Mark already said, and I heard him, watch this little trick. He's gonna go down Wednesday. We're going to the same fucking judge. I promise you.
So
He said, we're gonna,
Torres
he
or
said,
Nieto?
to skip per sightings, right, Judge? That's the last thing he said in that courtroom.
But that's not in the order.
I know, but that's what he said, and he's done this to me every time. Why do I have the same judges over and over and over?
I don't know.
But that's because we keep going to the same ones. He does. He's gonna
So
do
what,
it
so what
Wednesday.
he can do Wednesday is he
Check it
can,
out, check it out. I've been in the court a million times, all right? And I knew I was gonna do this. How did I know? Somebody told me. I know I'm gonna sound crazy or whatever, but I know these things. So if I was gonna do that, and I knew all this stuff was gonna happen, I'm prepared for Wednesday. But something is going to happen that's going to change history, whether you bust these guys or there's dead bodies everywhere, bro.
okay.
Because I'm not living in a real world where I'm telling you all this stuff is going on and you're still not doing anything about it, like going anywhere. Not letting anybody, you have a suspicion that these guys, you told me you're on a council for corruption and all this stuff, but
No,
you
it's not a
haven't even
council
let
for
nobody know, maybe I have something and they can kind of help you
It's
on
not a
this.
council for corruption. It's a-
Whatever. My point. The only person who knows about this is you, and I still don't have my son, and they're refusing to sign something. That doesn't even sound right to me.
I agree with you.
Okay, so who do we talk to?
We have a hearing on Wednesday.
Yeah, we do.
Beyond doing my job, Ryan, I don't know what you need me to do, man.
It's criminal.
I don't disagree with you.
You're civil.
Right.
Where's the criminal? You haven't even let them know you have suspicion. That's what I'm getting at. You look nervous in that courtroom. You went in there and nobody else went in there but you and everybody else and not me.
I asked for your permission. You said I
you did
could
ask for my
do it.
permission, and you did walk in there. And ever since then, I'm still getting screwed.
All right, get out of my office.
See you later, buddy.
The state has paused at 12:20. Mr. Ireland, what did you take this statement? I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. What did you take that to mean?
I believe that was a threat that if he didn't get what he was seeking, that people would be hurt.
You're familiar with threats like these. That's true.
Yes.
What do threats like these look like?
I mean, I've been a family law attorney for almost 13 years. I've been threatened before. I think you have to take every threat seriously. So when those words were said, I believe them to be a real, true threat.
Your Honor, may I approach?
Yes.
I'm showing you what has been pre-marked as State's Exhibit 2. If you may look at this, then I'll ask you a couple questions when you look up at me. Do you know what this is?
Yes.
What is this?
That is a copy of a docket sheet that they use in the presiding civil court to assign cases.
Does it look like in the same condition as when you saw it in the past?
I don't know that I've seen that document before.
In your interactions on the civil side, is it normal practice to get notice of a court hearing in a form like this?
So those are created, those are what the presiding court judge uses to call the docket every morning. And then those slips are then marked by the presiding court judge depending on what's going to happen on the case. So those are used every day in presiding court.
The date on this document, what does it show?
April 23rd, 2025.
Do you recognize that date to be the Wednesday date you would have accompanied Mr. Allen to the court?
Yes.
And in the audio recording we heard when there's talk about Wednesday, is it this date?
Yes, it's that date.
Your Honor, the state moves to enter what has been pre-marked as State's Exhibit 2 into evidence for this hearing, pending review by defense.
I have no objections to this.
All right, State's Exhibit number 2 is admitted without objection for purposes of this hearing.
In the recording we just heard at 57 seconds, defendant says history is going to be made on Wednesday. Tell us the significance about that Wednesday date.
That was the date we were set for a temporary orders hearing. Mr. Allen had up until that point supervised possession and access of his son, and we were hoping to get unsupervised possession and access.
You did not have a scheduled interview with defendant on the day in question. That's true?
That's true.
And if you may please explain to us how defendant came to be in your office.
He just showed up.
Had he spoken with anyone before speaking with you in your office?
I think he met with my front desk receptionist.
Her name is Patsy.
That's correct.
Why did you accept this interaction with defendant when he hadn't had a planned meeting with you?
I had availability in my calendar. I had about a half hour to 45 minutes available, if I remember correctly. And I knew he was anxious about the hearing, and so I thought I'd give him some of my time to hopefully make him feel better.
You had never recorded a conversation with you and Mr. Allen before. That's
No.
true.
That's correct. Sorry, that's correct.
It is not your normal practice to record conversations with clients.
That is also correct.
After defendant said, I'm prepared for Wednesday, something is going to happen that's going to change history. Bust these guys or there's dead bodies everywhere. Who was the first person you called after that?
I called the State Bar Ethics Hotline.
What were you advised?
That I had a mandatory duty to report what was told to me to law enforcement under Rule 105E of the Texas rules of the disciplinary rules for attorneys the ethical rules that we live by.
Why did they say you had an ethical duty to report?
Because the State Bar Ethics Hotline believed it met the standard in 105E.
Did you call anyone else?
Yes.
Who?
My attorney, Carl Cobb. That's KOLB.
What did attorney Cobb advise you?
I provided him the recording and then he advised me I had a mandatory duty to report it to law enforcement under Rule 105E.
Do you remember speaking with an investigator Lopez?
Yes,
When you initially called to report, you told Lopez your fear of the threat that there were going to be dead bodies everywhere, right?
yes,
You did not tell Lopez anything about any attorney-client privileged information.
no.
The recording we just heard, its total duration is 12 minutes, 54 seconds. It was at 10:45 that defendant said there's going to be bodies everywhere. How did you respond to that statement?
I was in shock. That was the second time he had said, we're going to make history on Wednesday. And I think at some point, even in my head, I said, don't say it. And then he said it, that there would be dead bodies everywhere.
After you reported this threat, what else did you do?
That day,
Well, you didn't feel safe. What did you do for safety reasons?
we locked our front door. And I excused my staff, whoever didn't feel comfortable being there.
Any other precautionary measures?
That day, no.
How about in the near future?
I arranged for my office to have active shooter training and also paid for my entire staff to be trained in handgun shooting.
You would agree with me that throughout this 12-minute 54 conversation, you agreed with a lot of defendants' statements in paranoia. Isn't that true?
I don't know that I agreed with the paranoia. I had felt like up to that point that Ronnie had gotten an unfair shake in the civil courts.
You had mentioned when defendant said, I'm scared, you agreed. This is a scary thing, right?
Well, I thought he was talking about, he was scared about losing his relationship with his son. And as a parent, like, I get that.
When defendant was talking about things are being overlooked, you agreed. You said, I think you're getting fucked for sure.
So that statement was because I thought, like I said, I thought he was getting an unfair shake in the civil courts based on my experience with Mr. Allen up to that point.
3 times defendant alludes to a specific date. What date was that?
I don't know. I don't remember.
When would dead bodies be everywhere?
I presumed based on the subject matter of the conversation, it would be on April 23rd, that Wednesday at the hearing.
At minute 57 seconds, history is going to be made on Wednesday. You remember defendant saying that?
Yes.
6 minutes, 52 seconds. I know Wednesday something changes in my favor. You remember that?
Yes.
10 minutes, 45 seconds. I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. Do you remember that?
Yes.
Your Honor, may I approach?
Yes.
I'm handing you what has been pre-marked as State's Exhibit 3. If you may please look at this briefly and then look at some questions when you're ready.
Okay.
Do you know what this is?
Yes.
How do you know what this is?
This is the transcript of a hearing. Well, the part of the final hearing for Mr. Allen's protective order.
What date does this have on it?
June 23rd, 2025.
What court does this have on it?
Well, the case is filed in the 150th, but it was heard by Judge Christine Hortick in the 225th.
Is this in Bear County, Texas?
Yes,
And does it look to accurately portray what it represents that it's portraying?
yes,
Does it look like it's been altered in any way?
no.
Your Honor, at this time, the state moves to enter what has been pre-marked as State's Exhibit 3, pending inspection by defense.
Judge, I'm aware of this document. I don't object to this in particular any more than I object to basically what is the core of the suppression motion anyways. So
All right.
no objections to that.
State's Exhibit number 3 is admitted for purposes of this hearing without objection.
At this hearing in State's Exhibit 3, it had something to do with a motion to withdraw as counsel. Is that true?
That hearing? No, that was not for my motion to withdraw as counsel.
Thank you. What was this hearing for?
That was the continuation of the final protective order hearing that Miss Allen had filed against Mr. Allen. And I testified that day.
There was discussion about a motion to withdraw, though, wasn't there?
Mhm.
And when asked about that motion to withdraw, you told the court that the defendant made a statement that you reasonably believed, led you to believe that the defendant was going to commit a crime that would result in the death or substantial harm to another person. Isn't that true?
That's true.
And this was 2 days before that Wednesday hearing. Isn't that true? When the statement was made.
Yes.
Now, please describe defendant's behavior while he was in your office.
He never sat down. He paced back and forth behind the chairs I have in front of my desk. He seemed very agitated. He was sweating profusely.
Were you scared in your office during this conversation?
Over the course of the conversation, I became more and more anxious.
When defendant said there will be bodies everywhere, were you afraid for your life?
Yes,
You were afraid for your staff's life?
yes,
You were afraid for the lives of the people at the courthouse?
absolutely.
You were afraid for defendant's family's life,
Yes,
to specifically include the children,
yes, his son Aiden.
the child, and the ex,
And I'm sorry?
his ex.
Yes,
Now, defendant never said, I'm going to, he didn't give a specific manner and means, didn't give a specific person. But what contextually made you believe this was an actual threat?
twice he said, I'm going to make history on Wednesday. And he said something was going to change. And when he made the statement, dead bodies everywhere after he said he was going to make history, that specifically.
Now, you mentioned playing the recording for your staff. That freaked them out, didn't it?
Yes, they were all very concerned.
Objection, hearsay.
Right, that'll be sustained.
Your Honor, the state kindly passes the witness.
All right, defense, you may proceed.
Mr. Ireland, you testified previously that you reported Ronald Allen during this visit to your office on April 24th or 21st of 2025. That's established. You recorded him.
Yes,
And you didn't advise Mr. Allen that he was being recorded, did you?
Objection leading.
All right, that'll be sustained.
Did you advise Mr. Allen that he was being recorded?
no,
And when you testified under oath in the civil court, you said in that transcript we referred to earlier, you said, when you said something inside you said to record it, what was it inside of you that made you think that that was going to be said in this interaction you had when he came into your office?
I didn't think anything was gonna be said.
Do you ever record any of your other clients? Ever? You've never recorded another client?
Maybe once or twice in the 13 years I've been practicing.
And the last client you recorded, was he referred to the police for making a threat?
Objection, Your Honor, relevance.
That'll be overruled.
I've never had to do what I did in this case.
So, but would you agree with me that in the actual recording, there's no real yelling or threats? In fact, it sounds like an attorney this is like a conversation between a pair of friends. Did you see it that way at all?
Objection, Your Honor.
Before-
Compound leading and attorney testifying.
Sustained.
Do you think Ronald Allen thought of you as a friend and an ally in the custody case?
Objection, Your Honor, speculation.
That'll be sustained.
Do your clients usually see you as a friend and an ally in their custody case?
Objection, Your Honor, relevance.
That'll be overruled.
I don't make friends with my clients while their case is active.
You have a friendly way of speaking to them, don't you?
Yes,
And if you say to Mr. Allen, I think you're getting fucked, man, does that mean that literally he's going to get raped or something? Or does it just mean in a figurative sense?
Objection, Your Honor, speculation and compound.
That'll be overruled.
In a matter of speaking, when you say something like that on the record and you know you're being recorded, do you think that it should be taken as a literal sense that he's going to go and get raped in the court? How do you mean that when you say it?
as I said earlier, I believed up to that point, Mr. Allen had gotten a bad shake in the civil courts.
So, did you ever give a written statement to law enforcement about this alleged threat?
What do you mean by written statement?
Did you ever write something out and swear to it and give it to the investigators?
No.
But it is true, isn't it true that you emailed or texted the audio file to Che Lopez, the investigator for the state?
Yes, I did.
Objection, Your Honor, leading.
That'll be overruled.
I think I can ask leading questions here because I'm on a redirect, right?
No,
Okay.
not on redirect.
Did you password protect the file to ensure the chain of custody on the MP3 that you sent to the investigators?
Objection, Your Honor, leading.
I'm just asking him a question.
All right, so I'll just make a ruling on objections that are made. So that objection will be overruled. You can answer that question.
I don't recall.
Is this the first time that law enforcement was ever involved at your initiation? Like that you called the police and had them?
In my professional life?
Yes, as a lawyer.
Yes.
So would you acknowledge that your decision to disclose these communications that you had with Ronald Allen, that was Was that solely based on your belief that Mr. Allen might commit a future crime?
No, because I believed that what he told me clearly established that he would.
Did he have any weapons on him?
I don't know.
Is there anything in your family law questionnaire that asks if somebody owns firearms?
Objection, Your Honor, relevance.
Relevance.
Well, I want to know if he anticipated that Mr. Allen had the means or ability to carry out any kind of threat.
All right, you can answer that question.
My intake form does have that question type of questioning.
And did you know that in your review, you reviewed the entire docket sheet and history of Mr. Allen's custody case that he had with his son Aiden, right?
Yes.
And you knew that it was a long history that was going on, didn't you?
Yes.
And you knew that, and you've already said in this court that you didn't think he was getting a fair shake on the whole matter.
Objection, Your Honor, leading.
All right, that'll be sustained.
So can you explain to me your understanding of Rule 105 of the disciplinary rules of professional conduct on these cases?
The entire rule or just 105E?
Maybe you could tell me your understanding about it.
What part of the rule?
Well, I think people generally understand that attorney-client communications have some confidentiality. I think people have an expectation of privacy when they're talking to their lawyers. But what's your understanding of this?
My understanding of Rule 105 by itself is that I have a duty of confidentiality of attorney-client communications between myself and my clients.
Now, did Mr. Allen, in the recording we all heard, did he ever mention any specific names or intended victims in his narrative, what he was talking to you?
No.
And have you ever heard a manner of speaking like, I just want to know if you've ever heard somebody say, well, that guy knows where all the bodies are buried. Have you ever heard that?
Objection, Your Honor, relevance.
Relevancy.
The relevancy is to see if he understands that there's manners of speaking that don't necessarily constitute a threat.
All right, that objection will be sustained.
Have you ever heard somebody say something that if they didn't understand normal language or expressive language, that it would probably raise some alarms if they didn't understand?
Objection, leading, and relevance.
Sustained.
In that recording we all heard, when you heard Mr. Allen expressing concern over being summoned for the jury duty in the same courthouse as his custody case, what went through your mind when he told you about that? About being
It was a weird coincidence.
If that kind of weird coincidence happened to a different client, do you think that that's the kind of thing that somebody would come into their attorney to talk about?
Objection, Your Honor, relevance.
Sustained.
Who else could help Mr. Allen, other than a lawyer, understand whether that's a coincidence or not?
Objection, Your Honor, relevance and speculation.
That'll be overruled. You can answer the question.
I don't know that I understand your question.
Well, if I'm suspicious of some coincidence like we're talking about here, being called for jury duty the same week as your trial, if I'm trying to figure out if that's a coincidence or not, and it has to do with things that happen in the courthouse, don't you think that it's appropriate that he would call out that kind of suspicion to his lawyer?
Objection, Your Honor, that's speculation as to what asking us to,
I'm trying to explain the question.
and the state is saying this is an inappropriate question. This is
All right,
It's
I'll-
leading and speculative.
all right, I'll let him answer the question.
It's a weird coincidence, yes, but jury summons are sent out weeks in advance. That hearing had only been on the books for about 10 days. So some notion that it was some sort of conspiracy can be swept away very quickly.
But you didn't tell him that in that recording that we just heard, did you?
Nope.
Do you wish you had?
Objection, Your Honor, relevance.
All right, that will be sustained.
You never attempted to, did you ever attempt to refer Mr. Allen for any mental health treatment prior to recording him that day?
No.
And did you contact Miss Anna Hesbrook Ramirez the same day as that recording was made?
Objection, Your Honor, relevance.
Well, that'll be overruled.
Did you contact Miss Anna Laura Hesbrook?
I don't remember.
And did you ever, before calling either Miss Hesbrook or the police or the Che investigator, did you inform Mr. Allen that you had recorded him?
The state is going to object that this line of questioning is outside the scope of this hearing.
That'll be sustained.
So you think it's fair to record somebody, send it to the police, and you never even let the person know? What did you mean?
Objection, leading.
That'll be sustained.
Did you know that Mr. Allen only learned about the being recorded after he had been arrested?
Objection.
Did you know that?
Your Honor, speculation.
All right, that will be sustained.
Did you ever try to call Mr. Allen after that recording and try to ask him what he meant when he was talking about bodies?
Objection, Your Honor, relevance.
That'll be sustained.
Did you text Mr. Allen back to your office before recording him? Does your office ever text clients?
All the time.
Did you ever text Mr. Allen to your office before this recording?
I don't understand what you mean, text him to my office.
Send him a text saying you can come into the office now? Did you send him a text?
I don't think so.
You said you agreed with him regarding the coincidence being alarming, didn't you?
Objection, Your Honor, leading.
You said that, or did, pardon me, go ahead, Judge, sorry.
That would be sustained, no problem.
Who is Esparza in the recording? They're talking about Esparza. Who's that?
Dr. Fernando Esparza, he's a forensic psychologist in San Antonio.
So was that somebody that Mr. Allen was being referred to for a psych evaluation, or what was the purpose of discussing Mr. Esparza?
Objection, Your Honor, to relevance and outside the scope.
All right, what is the relevancy?
Well, earlier he testified that there had never been any recommendations for psychological evaluation, but now we're talking about Esparza in this recording. So I'm just trying to understand.
All right, but how is it relevant to whether or not this should be suppressed?
Well, I think psychological evaluations are confidential as well. And psychological impressions are confidential typically.
All right, you can ask that question.
So who was Dr. Esparza and why were y'all talking about him?
I don't remember why, he was appointed by one of the judges. I don't remember what his role was, though. I don't believe it was for a psychological evaluation. Dr. Esparza does many things in family law cases. Psychological evaluations is one of them.
Was he evaluating the child?
I don't remember.
When he was talking about the two girls that were in the court that represent Via, that were mad dogging him, mean mugging him, do you know who he was talking about?
No idea.
When you talk about Justin in this recording, who is that?
Justin Cook.
And who's he?
He's an attorney here in San Antonio. He was Mr. Allen's attorney prior to me.
Did you ever talk to Justin about the case?
Objection, Your Honor, relevance.
Relevancy?
Well, I'm asking to see if Mr. Ireland had a confidentiality that extended to the prior lawyer, or if he understood that the prior lawyer also had some confidentiality duties. So I'm trying to find out, if we're talking about the prior lawyer, if Mr. Ireland ever got anything that should have been confidential from the prior lawyer.
All right, that objection will be sustained.
In this conversation, you're actually talking about legal tactics and things that you're going to be doing in the near future. Specifically, you're talking about making a subpoena for a Mr. Sherwood. Why would you?
Leading this entire phrase.
I didn't even finish my question.
All right, so just address towards me. Ask your question.
Why is Sherwood so important to subpoena in this conversation?
All right, so any objection to that specific question, State?
Yes, Your Honor, it would be relevance still and outside the scope.
All right, that'll be sustained.
Had you had any prior meetings with Mr. Allen before that day?
Yes.
Did you ever record him in any of the prior conversations that you had with him?
No.
Did you feel like he was questioning your role as his lawyer at that meeting?
I think a little bit, yeah.
Because in the beginning, he says, well, in the beginning, you said something along the lines of, well, if you're not happy with me, you can fire me. You said something like that, right?
Yes.
And so very early in the conversation, did you believe that you were on the defensive?
I don't know about on the defensive. I was just trying to reassure Ronnie that I wasn't scared. And, you know, I've been doing this a long time, and I didn't particularly care for the way he was questioning my tactics, I guess.
But you stayed in the room with him for several minutes after that comment, right? I mean, it was a while.
Objection to leading.
All right, that'll be overruled.
Did you stay in the room? Did you stay in the room with him for several minutes after that comment?
Approximately 13 minutes, however long the recording is.
You didn't feel, did you feel alarm or feel threatened yourself personally in that moment?
When he said there would be dead bodies everywhere, yes.
When you told the did you ever tell the police that Ronald said, if I don't get custody, I will make history and there will be dead bodies everywhere? Is that what you told the police exactly?
I don't remember. I might have.
Did Ronald ever describe any kind of plan to execute the dead bodies in the courthouse? Did he give you a plan?
Objection, Your Honor. This answer calls for hearsay.
That will be overruled.
The last time I talked to Ronald Allen was that recording. Anything before that is attorney-client privilege.
Oh, you have did you have a written contract with Mr. Allen as a lawyer?
Yes,
And your contract, does it include language that communications with a client are confidential?
yes.
Objection, Your Honor, outside the scope.
That'll be overruled.
It's a contract, Judge, and
I overruled the objection. You can
Thank you.
answer. You can answer the
Um,
question.
do you have that kind of term in your contract?
Yes,
Were you paid to represent Mr. Allen in that custody case?
it was.
And you received funds from him or on his behalf in support of that contract, right?
Yes.
And have you refunded any part of Mr. Allen's retainer?
Every cent of his retainer that was remaining in my trust was immediately returned to him.
Looking back, is there any way that you would have handled this differently that you'd like to tell the court about?
Objection, Your Honor, that is outside of the scope of this hearing.
Sustained.
Would you handle it differently if you had to do it today?
Objection, Your Honor, relevance.
Sustained.
That's all I have, Judge.
All right.
That's the witness.
Any recross?
Perhaps briefly, Your Honor, I may have 1 moment. Your Honor, the state is done with this witness. No further questions.
All right, may this witness be excused?
Yes, Judge.
All right, thank you. You may step down if you'll leave the square microphone.
Thank you, Judge.
Thank you. All right, defense, call your next witness.
That's the only witness regarding this motion, Judge.
All right. So from what I'm reading from the motion, counsel, with regards to your motion to suppress, subtitle 2 and 3, both parties have stipulated that there was a warrant. With regards to 4, the real question is whether or not this was attorney-client privilege. And is there anyone who disagrees that if an attorney presumes or assumes that a threat is being made, that is not a part of attorney-client privilege?
That's how the state understands that exception.
All right, defense, do you want to address that?
Yes.
Your Honor, the state does have 1 witness to call.
Oh, so you have another witness for the motion to suppress?
Yes, Judge.
I'm so sorry. You may call your next witness. You may call your witness, state.
And state is going to call Investigator Lopez, badge number 142.
Okay. I'm sorry about that. I didn't know the state had witnesses. All right, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, just give me 1 moment. Everyone, just give me 3 minutes, please.
Judge, if the state may ask for a quick restroom break.
We're putting this man on.
Yes.
Okay.
All right, so you're under oath. Could you state your name for the record, please?
Yes, ma'am. My name is Investigator Che Lopez with the Bexar County Sheriff's Office.
All right, state you may proceed.
Yes, Your Honor. The stately approach.
Yes.
I'm handing you what has been pre-marked as State's Exhibit 4. You may look over that briefly and then look back at me so I may ask you a couple questions. Do you know what this is?
Yes, sir. It is our report. The Bexar County Sheriff's Office report.
And how do you know that's what it is?
This is what I'm familiar with. The initial officer makes the report and then I do supplements inside this report.
Does it have your name on there for us to know that this would be your report?
Yes, sir, it does.
And does it look like it's been altered in any way?
No, sir, it does not.
Do you remember the date, April 21st, 2025?
Yes, sir, I do.
Why do you remember that date?
It's when this case was first assigned to me.
And what is this case about?
Threats to the courthouse.
Do you know who is accused of making that threat?
Mr. Allen.
Do you see him in the courtroom today?
Yes, sir, I do.
May you please point him out and identify him by an article of clothing for the record?
Yes, sir. Mr. Allen's wearing a Bexar County orange jumpsuit, sir.
If the record may reflect that our witness has positively identified the defendant in the courtroom. Now, do you remember hearing a recorded statement as it is related to this case?
Yes, sir, I did.
How did you get this recorded statement?
This case was initially brought over by SAPD Fusion, which was then given to my supervisors. My supervisors assigned me, and that's when I made a phone call to Mr. Ireland.
And who is Mr. Ireland?
Mr. Ireland is our witness and also Mr. Allen's attorney.
Did you hear the recording?
Yes, sir, I did.
What was alarming about the recording?
During the context of the conversation, he advised that the court and the court officers were he was in contention with them. He believes that it was him against the courthouse, if my understanding of the audio recording was correct. And then later on, he stated that there will be something going on Wednesday, and that there'll be bodies everywhere.
But we would object to this as to hearsay. We already heard a direct witness.
State.
Your Honor, we were merely asking how the investigator came to know about this case and his familiarity with the recording, and he has corroborated what this court has heard.
All right, that objection will be overruled.
You mentioned a specific date, Wednesday. How did you know that there was specificity to this threat?
He mentioned Wednesday several times, and also when I reviewed court documents, he had a upcoming custody hearing on Wednesday, April 23rd, 2025, I believe.
Your Honor, may I approach?
Yes.
I am showing you what has been entered as State's Exhibit 2. Is this the document you are referencing?
It's one of them, sorry.
Now, this one, you had mentioned a date. Do you see that date reflected at the top?
Yes, sir, I do.
What date?
4/23/25.
So that is the Wednesday repeated date that we heard in the recording.
Yes, sir.
Was the threat specific to a date?
It was specific to a date and I believe a place. Other than that, we didn't have a means yet.
And your understanding with terroristic threats, were those elements met even without the specific manner and means?
I believe so, sir. The threat was in reference to the trial if it did not go a certain way. And I believe he was inferring that he would disrupt proceedings, or he wanted the proceedings to go his way.
And what was the threat if proceedings did not go his way?
Dead bodies everywhere.
Did you generate a warrant for the arrest of the defendant?
Yes, sir, I did.
I may approach, Your Honor.
Yes.
I'm showing you what has been entered as State's Exhibit 5. Do you recognize this to be the warrant?
Yes, sir.
And it's got your name associated with it?
Yes, sir, it does.
Your Honor, the state kindly passes the witness.
All right, defense.
Did Ronald Allen ever disrupt any proceedings in the courthouse to your knowledge?
Not that I'm aware of, sir.
You didn't observe him disrupting any proceedings?
Objection, Your Honor, leading.
I'll let him ask. You can answer that question.
I did not witness.
And did you speculate as to any means that Mr. Allen's might have had to be able to effectuate this threat?
No, sir.
Were you there when the threat was made?
No, sir.
Did you speak to anyone else related to the custody case regarding this incident?
Objection, Your Honor, relevance.
That'll be overruled. You can answer that.
I subpoenaed, but I did not get any records from KidShare. So no, I did not speak to anybody in reference to the custody case.
Did you speak with Anna Laura Hesbrook?
Objection, Your Honor, outside the scope of this hearing.
Sustained.
I do not believe so, sir.
The objection's been sustained. That's okay.
Apologize.
You may continue, counsel.
Did you ever interview Mr. Allen regarding this incident?
No, sir, I did not.
Now, in your report, you said that there would be dead bodies everywhere. But did you see that that's a misquote to what's actually said in the recording?
That's what I heard in the recording.
So would you be surprised if the recording said something different?
Objection, Your Honor. That is. The state will withdraw that objection.
Okay. All right, you can answer the question if you can answer the question.
I listened to that audio recording several times, and to the best of my knowledge, to what I heard, that was correct.
That's all I have for him now, Your Honor.
All right, any further questions?
No further questions from the state, Your Honor.
All right, you may step down. If you'll just remove the microphone.
Thank you for reminding me, actually.
Sure. Any other witnesses from either side?
None from the state, Your Honor.
Defense?
None from defense.
All right, so what we'll do is we'll come back tomorrow and I'll hear arguments from both sides. And if both sides will be prepared to argue the motion to dismiss as well as the motion to suppress. And as stated, we'll take up the motion to suppress first. I'll make my ruling and then we can take up the motion to dismiss.
Thank you, Judge.
All right, thank you. Is there anything else?
Nothing further from the state, Your Honor.
All right, then defense, anything else?
I'd like to confer with Mr. Allen for a few moments, if that's okay.
All right, are you planning on calling him or no?
That's what I want to talk to him about.
All right, if you can state if you'll step outside to allow him to speak with him. And counsel, what I
think we're gonna try it.
Are you gonna call him?
Yes.
All right. If someone would tell the state to come in, and sir, if you'll take the witness stand, please.
Yes.
Sure. All right. Defense, you may call your witness.
Yes, Judge, we're calling Ronald Allen.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. If you'll state your name for the record, please.
Ronald Allen.
All right, you may proceed.
Mr. Allen. Why did you say what you said in that recording?
Because I felt like the judges and the lawyers weren't taking this matter serious enough. I think that they were the reasons why my cousin committed suicide. And I believe that all the violence and all the murders that are with the family cases are because of they're toying around with it. And I think that there's dead bodies everywhere because of it. Every family situation, murder suicide I see on the news was related to a family dispute gone out of control. And that's what I was referring to.
And how many times have you been in the civil court?
236 times.
And that's how many temporary orders and settings that have been made?
Yes, sir.
236 times?
Yes, sir.
Leading, but also this is outside the scope of this hearing.
All right, that will be sustained.
Do you possess any firearms?
Nope.
Other than your ex-wife, has anybody else ever accused you of being violent?
Nope.
Objection, Your Honor, relevance.
Sustained.
What are your feelings towards Mr. Ireland now?
Objection, Your Honor, relevance.
All right, how is this relevant to the motion to suppress? And I understand the rules of evidence and that privilege. Communications of privilege, I understand how that relates to motions to suppress. And I understand that technically the rules of evidence do not apply to motions to suppress outside a certain number of rules. But with regards to this, how is this relevant to anything about the motion to suppress?
I think it's worth it for Mr. Allen to be able to say how he feels betrayed by his civil lawyer.
All right, that'll be sustained.
How many other civil lawyers have you had?
At least 20 something.
How is this relevant and this is outside the scope?
All right, that'll be sustained as to outside the scope of the hearing.
Well, Judge, I think that's kind of a hard item. I mean, we've acquiesced to let him testify in this suppression hearing because we think that he has an expectation of privacy regarding his communications with his own lawyer.
All right.
He should be able to talk about that, we believe.
Well, with regards to his expectation of privacy, because I'll note for the record, this hearing is a combination, I believe, of the motion to suppress and the motion to dismiss. So I'm I will take this hearing as a combination of your motion to suppress and the motion to dismiss. Is there any objection from either side to the court hearing evidence for both of the motions at the same time?
No objection from the state.
I'm not opposed, Judge.
All right, if there's no objection from the state and the defense, then because you all are saying that you want the motion to suppress and then the motion to dismiss heard at the same time, then I will hear testimony from the witness with regards to your question of expectation of confidentiality.
And we think that's the efficient route.
Okay. All right, you may proceed.
Mr. Allen, you had so many different lawyers on your cases. Have any of them ever disclosed confidential information to the opposing counsel, to the representative for the child, or to the court generally?
The state is objecting to relevance outside of the scope. In support of that, we're talking about representation from other people. This is not relevant, and it does not go to what Your Honor has narrowly allowed expectation of confidentiality. This is outside the scope.
All right, so counsel, that objection does not pertain to your motion to dismiss or to the motion to suppress. So response
Well,
as to what other attorneys did.
well, I think it is relevant because it tends to, we're talking about an experienced person in relation to attorneys and what kind of expectations that he has regarding privacy and what is typically contracted in a civil attorney contract.
Right, well, you can question him about his expectation of privacy as it relates to Attorney Ireland.
Okay.
All right.
Did Ireland ever call you and ask you anything about your statements made in the office and the recording we heard?
No, he did not.
Did Ireland ever tell you that he was going to call the amicus attorney or call the police regarding what you said?
No, he,
Objection, Your Honor, relevance, but also an appropriate witness. We had Mr. Ireland on the stand and all these questions. There's a better witness for that.
He's a party to that conversation, Judge.
All right, I'll let you, and I'll let him answer the question.
no,
Did Mr. Ireland ever ask you what you meant in that moment?
no,
Did Mr. Ireland ever express any fear or recoil? Did he act scared when you were in that meeting with him?
no.
What were the last things that Mr. Ireland told you at the end of that recording?
Get out of my office.
Yeah. When Mr. Ireland said that you were getting effed, did you think that he meant that you were literally going to get effed?
Objection, Your Honor, relevance. This is beyond the scope, and those are the state's argument.
All right, beyond the scope of the motion to suppress or the motion to dismiss?
This would be for both. They're talking about what words mean or should mean or literal meaning, and it has no business in either the motion to suppress or the motion to dismiss.
All right, that objection will be sustained. You can ask your next question, counsel.
What do you expect when you walk into an attorney's office?
What do I expect when I walk in? Well, confidentiality, of course.
Do you expect that the attorney's going to be on your side?
Absolutely. Or you sign a contract with them. It's there.
And did you ever try to get, did you ever try to hire your wife's lawyer?
Objection, Your Honor, relevance.
Sustained.
Would your comfort, would you, when you talk about dead bodies, would you have that kind of conversation with Ms. Hesbrook or with the opposing lawyer?
Objection, Your Honor, relevance and outside the scope.
All right, that'll be sustained.
Did you have any means to execute any kind of threat?
No,
Did you have any kind of intent to threaten anybody in the courthouse?
no,
Did you have any intent to threaten Mr. Medley?
no,
Did you have any intent to threaten your ex-wife?
Objection, Your Honor. It is beyond the scope of both motions.
Our motion to dismiss talks about mens rea and the intent and the mind of the accused. And so I think if he's taking the risk of subjecting himself to a cross-examination from Mr. Duffy, well, then he can ask his questions as much as he wants
Well,
on
what-
redirect.
What I can tell both parties with regards to mens rea and whether or not he had the appropriate mens rea, that is really for a jury to decide and not for the court to decide whether or not he acted knowingly, intentionally, unless you all are coming to the court for a bench trial. Otherwise, that's
not what
really
this
within the purview of a jury.
Right, Judge. We're agreeing to move forward for this on a suppression. Mr. Allen is agreed to give his testimony regarding the suppression and the dismissal motion, but he's not giving his consent to be heard in front of a jury right now.
No, I'm just saying
That's
that
the problem.
the mens rea part of it,
Mhm.
that would only come down to, jury trial or a bench trial, not for necessarily a motion to suppress or for me to determine in a motion to dismiss whether or not he exhibited the appropriate mens rea.
Okay,
That would be the state's argument, is it's outside the scope of this hearing and it should be a matter for the trier of fact.
All right.
fine.
So that objection will be sustained.
Mr. Allen, what's your understanding of free speech in the United States?
then you have the freedom to speech, exactly what it means.
And do you think that that your attorney's office is a location where you can execute that right?
Objection, Your Honor, relevance, but outside the scope as well.
All right, that'll be overruled. I'll allow him to answer that question.
Absolutely.
Why?
Because one, it's America. Number two, it's because when you talk with your lawyers, you're supposed to be in confidentiality.
Is it because you're making plans with your lawyer regarding the tactics that you're using in the litigation?
Absolutely, hence the confidentiality.
Would you want the other side to know? Would you want your wife's lawyer to know what you've talked about with your lawyer?
Objection, Your Honor, outside the scope.
Sustained.
Mr. Allen, why do you think that the court should suppress the audio recording made by your prior lawyer?
Objection, Your Honor, speculation, but also calls for a legal conclusion to which this witness is inappropriate.
Sustained.
In that recording, you were expressing some fear, frustration, and using some of this language. Was this, and this is a question, was this something that you had a plan? Did you think that you were committing a crime by going in and talking to your lawyer about these things?
Objection, Your Honor, relevance and speculation.
All right, that'll be overruled. You can answer that.
Did you think you were committing a crime when you went in?
Absolutely not.
I'm going to pass the witness.
All right, state.
Just a brief moment, Your Honor, sorry. Your Honor, the state has no questions.
All right, you may step down. Cindy, don't forget your microphone. Any other witnesses?
That's it, Judge.
State any further witnesses?
No further witnesses from the state, Your Honor.
All right, then we'll close the hearing and we'll come back tomorrow morning and I'll hear arguments on both motions.
Shall we expect that to be at 9?
It depends on when he gets here. All right. All right, thank you, everyone.
Thank you, Judge.